I am Morgan Kirley. I'm a patent attorney here in the Chicago office of the Polsinelli law firm, and I focus primarily in biotech, but really any type of patents or IP. So with NDAs, I think that the common misconception is that they are bulletproof, or that you don't have to think twice before getting into one or relying on one. If you don't really trust the company or the entity on the other side, you have to ask yourself, well, what if they break it? Am I really going to sue someone for breaking a non-disclosure agreement? And also, what are the loopholes? Frequently, non-disclosure agreements aren't non-competes. So they can compete against you, they just can't disclose how they got the information or what's the term. So sometimes once the information is shared, the counterparty can then take that information and then compete against the original party, but they never actually disclose the information. So the spirit of the NDA is defeated, even though it's actually the word of it is being obeyed. I would think about three things. I would think about containment, ownership, and control. With containment, once the information's out, you might not know where it's going. You don't know what the other company or entity is going to do with that information, whether they're going to develop their own line of products or incorporate into their business strategy in ways you couldn't anticipate. So once the cat's out of the bag, it's difficult to get it back in. The second thing is ownership. Even if things progress in a way where it's a bunch of great things are discovered and the collaboration is very effective, who owns it? Which parts? All of it, some of it, part of it. So it's really helpful to have an agreement that governs that both sides can reference. And then also control. That goes hand in hand with the containment and the ownership. Who has the right to use the information? Can they use it for regulatory filings? And there's certainly agreements that are built for that purpose. So I would advise to use something that covers at least those areas. It really depends on the context. Historically, sort of works for hire are generally by default owned by the entity or the person that's commissioning them. But certainly there are exceptions to that. So if there are contracts or agreements in place that change that default, then it can be different. In this case, the company wants to own it. They should specify, yes, this is a custom-made product, but we at least retain rights to X, Y, or Z. It's best to put it in writing, which people might not be used to doing, but it's always good. So that's really tough. Certainly there are famous instances of it happening. The founder of Theranos, famously filed her own patent when she was still in school. The founder of Spanx, I believe, also did something similar because the costs are high, but it can really backfire. A lot of times those filings aren't as complete. They don't have the necessary support. And if they're done in such a way where it's more than 12 months before errors are caught, they're very difficult to fix. Oftentimes they're unfixable. So, in general, if you're in an area that is IP heavy, it's sort of a need to have, not a want to have. Yeah, I think the easy answer to that is trademark. They're much more cost effective. They don't provide the same types of protection. A trademark has to do with your brand names, your logos, things like that, sort of brand recognition from customers. But it's still very important. Patents are much more time-consuming, much more complicated, and much more comprehensive and expensive process. The reality is, probably every 6 months. Products get updated, systems get updated, things slowly evolve, version 2.0, version 3.0. And if you're not careful, you're going to outgrow your existing protection. And you don't want that to happen. Just like if you outgrow a pair of shoes, you want to make sure you have another one that fits, in the next size up. So, and bearing in mind, to the extent that you're making updates, adding new ingredients, changing components, you might want to change those too, because your competitors might be counting down the days until your original patent or your original IP protection is no longer acting there as a safeguard. At the startup stage, and particularly while they're still doing R&D, I think it's okay for startups to sort of be in stealth mode. As we've mentioned with some of the other questions, IP can be very costly, and all these analyses can be complicated. And if you're so concerned about analyzing thousands and thousands of patents, you can forget to develop your own product. But what I would say is, once you're getting to the point where you have your, MVP, your minimally viable product, and certainly prior to launch, that's when you want to think about it, because up until that point, the startup's not going to be on anyone's radar. So, maximize that R&D time, make sure you have your own innovative ideas, but then before you launch, before you go out of stealth mode, that's really the time to double check and triple check to make sure that you're clear. Certainly there are technologies that are more IP light and IP heavy. Certainly pharmaceuticals, is IP heavy. But with all of these, technology areas, one thing I would say is patents are becoming more frequent, not less frequent. So 10 years ago, 20 years ago, it might be 1 or 2 patents that cover a process or a composition. Now it's 50 or 100. So the scale at which the competitors in these spaces are sort of building their patent and IP war chests is quickening. So, people should be mindful of that, and companies and startups need to be mindful of that, because if that's the way things are going, then that's the field that they'll need to compete on.